Guys, good Saturday afternoon to you. A little bit of breaking news yesterday, coming out of Austin that will be relevant to a lot of us in San Antonio and across the state with regards to the mask mandates. A little bit of an update there. If you recall from my one of my last videos on I believe it was March 2nd, the governor of Texas, Governor Greg Abbott, declared that Texas was going to be open 100%, and he lifted the mask mandate across the state. Said that's it, no more mask mandate. It's all done. And if you watch that video, or if you've been paying attention to this saga, what you would have heard me say, and kind of the received wisdom of most folks in the space has been that local subdivisions, local political subdivisions, meaning cities, counties, municipalities, et cetera, cannot overrule the governor with regards to that order. And the way that we got that conclusion is based on the way that the mask mandate stuff first happened almost a year ago when the COVID-19 crisis was beginning to happen. And if you listen to most of the mayors and county judges and et cetera around the state talk, that's been near universally received consensus that while private businesses can of course set their own ground rules, that political subdivisions cannot overrule the governor. Well, Austin has given us all a little bit of a surprise. So in response to Governor Abbott's executive decision to lift the mask mandate, the city of Austin decided that they thought that was stupid and they weren't going to follow it. Again, surprised that Austin would march to the beat of their own drum. For those non-Texans, that's a little bit of deadpan sarcasm. It is not a surprise at all that Austin would decide to march to the beat of their own drum. And based on the advice of the chief city health official, doctor, they decided that they were going to continue to enforce their citywide mask mandate. At which point, Texas Attorney General Ken Paxton promptly sued them and announced the same on Twitter. In any event, this past Friday, the judge trying that case surprised everyone, I think. Certainly surprised me, I think surprised most other folks, by denying the state of Texas' request for a preliminary injunction. Now, what does that actually mean? Does that mean that the city of Austin wins? No, it does not. What it means is that in the interim, which maybe about 2 weeks or so until the next phase of that trial, that the city of Austin can continue to enforce their mask mandate. That there's not an injunction against them enforcing it. So it means for at least 2 weeks, maybe longer depending on what happens next, but for at least 2 weeks, the city of Austin wins. And some other officials around the state, including here in San Antonio, our Judge Wolf has all said publicly that they're watching the results of the Austin lawsuit, and if the courts come down and say that cities can overrule the governor, that probably a lot of these guys are going to overrule the governor, because it's very clear that they all disagree, or not all. It's very clear that they most disagree with the governor's lifting the mask mandate. So, in any event, really interesting news out of Austin. We'll see what happens next. It's certainly not time to take it to the bank and celebrate and do all that if you're one of these cities, but it's a breath of life into the lawsuit that I think a lot of people, myself included, didn't really expect would be there. This was, for a lot of us, it seemed like a foregone conclusion. Of course the city can't overrule the governor. We established this a year ago when the COVID stuff already started. Well, surprise, the judge in Austin disagrees. So stay tuned. And again, just so that everyone understands, this does not change the answer to the question that I got a few times on the last video, which is, if you are a local business, can you continue to enforce the mask mandate on your business property? And the answer to that is yes, provided that it's not only enforced against people of a certain race, sex, national origin, religion, et cetera, et cetera. That'd be contrary to the Civil Rights Act, and provided that you're not running foul of some other law that would make the enforcement of it otherwise illegal. The best analogy that I can give you is this would be uh, sort of like standing up in a movie theater and talking very loudly, or bringing a very bright flashlight and shining it around in a movie theater, or going and walking around a grocery store cursing at customers or something like that. That it's not necessarily illegal, right? It's not illegal to speak loudly. It's not illegal to dance. It's not illegal to shine a flashlight. It's not illegal to curse at someone. But all of those things would be against the house rules of the business, and provided they don't run afoul of Civil Rights Act or something like that, the business can exclude you from their premises for doing it. So a business can exclude you for not wearing a mask if they want to. They can say, please leave. Please don't come into our business if you're not going to wear a mask. If you refuse to, then you're now on the business without permission, and you're trespassing. So anyway, this decision by Austin, surprise, really interesting surprise. We'll see what happens. Nonetheless, does not change the answer to that question. Businesses can continue to enforce the mask mandate if they so choose, and city leaders are going to be paying attention. So thanks, and I'll see y'all next time. Like, subscribe, etc.